So my name is Sarah Rubidoux Lawson. I'm an attorney at Schwabe, Williamson, and Wyatt in Seattle. I practice federal Indian law and tribal law. For those of you that are into that sort of thing, I did my undergraduate degree at the University of Michigan. I have my law degree from the University of Wisconsin, and I have a master's degree in tax law from the University of Washington. I've been a practicing attorney for about almost 20 years now, which is frightening. And started my career off as in-house counsel for tribes. So started as a tribal attorney for the Tohono O'odham Nation in southern Arizona, and then went up to Washington State and was the trust real estate director for the Muckleshoot Indian tribe for 8 years, which is where I really got down and dirty with everything having to do with Indian trust land, including, of course, rights of ways. After that, I went to be in-house counsel for another tribe for a little bit before joining a law firm, deciding I was going to do something entirely different, and joining a law firm. And I really enjoyed the work that I get to do, especially with tribes who are trying to develop their land, either through economic development leases and getting the utility services there through rights of ways. Or I'll also work with companies that are trying to do business with tribes. For example, I assisted a real estate developer in Washington State with developing a multi-thousand, if not million square foot warehouse on Puyallup Tribal Trust land within the boundaries of the reservation. And the warehouse ended up being leased out to Amazon. And I represented the developer in that deal, but having come from the tribe side of the transaction, I was able to explain to the developer, why things take time and the other considerations that we needed to take into play. But with that, I'll go ahead and get started. So we're doing rights of ways on Indian land this morning. So my usual disclaimers that I think Brenda's heard a million times, but by merely being a participant here, you are not a client of Schwabe, Williamson, and Wyatt. These are general information only, and nothing I say here today is legal advice. If you want legal advice, you can go find an attorney. You can hire me later. But yeah, you're not my clients, and this is not legal advice. All right, so we'll start with some of the basics of rights of way. I know this is a CLE track course, but we get a lot of people who are non-lawyers, so I thought I would go ahead and start with the basics. A right-of-way is just an easement. It's the right to use the property of another, and a right-of-way is just one type of easement. There's lots of different types of easements out there. You have sort of what they call affirmative easements or negative easements. A conservation easement is sort of a negative easement, right? I agree not to develop this property ever. The other types of easements are just, the right to cross, the right to open a road. Sometimes it could be, a right to go through somebody's property to access a beach. The grantee rights are the privilege to pass over the land of another, and the grantor retains ownership of the underlying road or the underlying land. So if it's a road that gets built, for example, the state highway system only gets the right to construct that road along the surface, but the land underneath the road still belongs to whomever granted the right-of-way, unless, of course, they actually carved that section of land under the road out and granted that over to, for example, the state. There are several different rights-of-way statutes. There's the Rights of Way statutes for Indian land. The Railroad Act from 1899, the Telephone and Telegraph Act from 1901, the Public Highways Act of 1901, Oil and Gas Pipeline Rights of Ways from 1904, Rights of Ways for Power Projects from 1911, and then in 1948, Congress passed the General Rights of Way Act, which basically just allows rights of way for any other purpose instead of having to have these specific congressional acts that authorize specific types of rights of way. But it's important to pay attention to your authorizing statute and to know these authorizing statutes a little bit as you work with either older rights of ways that are existing on the reservation, or as you're maybe looking at renewals and then going forward. So know your authorizing statute. Pay attention to which law the easement was granted under. Make note of the year in which the easement was granted, and take note that perpetual easements weren't authorized until the 1948 General Rights-of-Way Statute. And I say this because I have seen a situation where there was a perpetual power line right-of-way that was granted in 1943. Well, in 1943, the General Rights-of-Way Statute, was still 5 years away from being passed, and so there was no authorization from Congress for perpetual rights-of-way. So technically, that power line right-of-way was granted under the 1911 Power Projects Act, which contained a statutory limitation of 50 years. But we'll get into that as we get more into these statutes. So the 1899 Act for Railways, Telephone, and Telegraph. I apologize if I'm tripping over myself this morning. I thought that I was drinking actual coffee, but I accidentally put the little decaf K-cup in there. So this is my first cup of coffee, and I have not figured out how to speak yet. Railroads, Telephone, and Telegraph Act, which authorized rights-of-way through Indian country for railways, telephones, and telegraphs. It did not require the consent of the tribe or the allottees. There was no term that's specified in the act. It does require compensation, though, to the landowner. And the grant is limited to railroad companies. So only railroad companies could have rights-of-ways opened up under this act. And there's the 1901 Highways Act, so 25 U.S.C. Section 311, that allowed state and local governments to open and establish public highways, quote, in accordance with the laws of the state or the territory in which the lands are situated. That language actually became really important later. There was a case that said that states could piggyback other services, I guess, let's say, within an existing right-of-way if the laws of the state allowed for it. So you would have perhaps a highway right-of-way that was granted to the state, and then the highway allows fiber optic to come through that same right-of-way highway corridor, or allows power lines to come through the corridor. So long as the laws of the state authorized it, they could piggyback services like that. That's changed a little bit with the new regulations. I keep calling them the new regulations, but they're almost 10 years old at this point. That changed a little bit with the new regulations, but we'll go over that when we get there. It authorized highways through Indian reservations and lands that are allotted out. No compensation was specifically required, but under the United States Constitution, if the government is going to take your land, take your property, you have to be paid just compensation. So even though the statute doesn't require the payment of compensation, the U.S. Constitution does. There's no tribal or allottee consent required under this act. It does, based on the language in the previous slide, allow piggybacking of utility lines. It does not allow inverse condemnation, so they can't build the road and then say, oh, well, we built it, so we'll just pay you for it. And there's no term that's specified under this statute. 25 U.S.C. 319, the specified purpose was for the construction, operation, and maintenance of telephone and telegraph lines. Unlike the previous act, so the 1899 act was limited to railroads. This one allowed other utility companies to go ahead and extend telecommunication lines via rights-of-ways on Indian land. Again, no tribal or allottee consent was required, but compensation was required, and there was no term specified in the act. Pipelines. So pipelines were authorized in 1904 for oil and gas purposes. Again, no tribal or allottee consent was required under the statute. There are special rules in that statute about lateral connections. Compensation was required if they were going to go ahead and put a line through. And this particular statute provided for a tax. So it says, I think it's a tax of $5 per lineal foot or something like that. It's a very small amount that's supposed to be paid under this statute. And then the other interesting thing about this particular statute is that it limited oil and gas pipeline rights-of-ways to a 20-year term with one 20-year renewal. Again, this comes up. You see this in the regulations that were issued in 2015, where they say, okay, tribes can agree to whatever term of a right-of-way they want, but individual allottees are limited by the statute. BI won't approve a right-of-way on allotted lands for oil and gas purposes longer than a 20 plus 20 because of the statutory restriction. Electric power and communication lines. Oh, hold on, I want to go back 1 second. There's also an interesting case that's going on in Wisconsin about oil and gas pipeline rights-of-ways. There is a oil and gas line that runs through a reservation in Wisconsin, and it runs across both tribal trust lands and individual trust lands. And on the tribal trust lands, the tribe had agreed to, I believe, a perpetual right-of-way across the tribal parcels. But for the individual parcels, of course, we have this statutory limitation, and so the pipeline right-of-way was limited to a 20 plus 20. Well, that 40-year term has expired. The tribe has come into ownership of some of those individual allotments, and now the tribe is suing the pipeline company because they don't want to renew the pipeline right-of-way. They want them actually to remove the right-of-way. So it's been an interesting case to sort of watch. All right, moving on to electric power and communication lines. So 1911 Act, power poles were covered in 1911, and then communication poles were added in 1952. This allowed for easements so long as they were, quote, not incompatible with the public interest. I don't know that I've ever seen a finding of something being incompatible with the public interest. Again, it didn't require tribe or allottee consent. No compensation was specified, but again, we have the constitutional requirements. And these lines were limited to a 50-year term. So the example that I gave earlier of a power line that ran through trust land on a reservation was a giant 600 kilovolt or something transmission line. And it was given as a perpetual right-of-way in 1943. Well, it could only have been granted under the 1911 Act, which specifies a 50-year term. So technically, that right-of-way would have expired. Hydroelectric dams and transmission lines were authorized in 1935. It's interesting when you look at when these acts were passed and you think about the periods of federal Indian policy. The first acts were all passed during the sort of allotment and assimilation era of federal Indian policy. But in 1935, we're in the Indian reorganization, Indian New Deal era of federal Indian policy. And so this statute is a little bit different than all of the previous statutes. It limits to a 50-year license, must not be inconsistent for the purposes for which the reservation was created, and must be necessary for, and it must be subject to conditions necessary for the adequate protection and utilization of the reservation. So it doesn't allow for hydroelectric projects that would theoretically flood an entire reservation such to make it unusable, right? It requires payment of reasonable use charges and also requires tribal consent, which was the first time in a statute that we had tribal consent be required. And then in 1948, we have the General Rights-of-Way Act. This is what I think most rights-of-way are granted under in the modern day. It's for any purpose except for hydroelectric. Hydroelectric still has to go under the 1935 Act. Consent is required. Individual consent is not required in certain circumstances. Compensation is required under the statute. And it also preserved all the previous rights-of-ways that were granted under previous statutory authority. So the new statute didn't say that all of those other statutes are now superseded. It just said, we're going to have another statute in addition to all of the other statutes. And then we have the Indian Tribal Energy Development and Self-Determination Act. This was in 2005. There were some amendments that were passed in 2017. But it allows tribes more self-determination and sovereignty over their lands. Tribes have a limited ability to grant rights-of-way over tribal lands. for pipelines and electric lines without BIA approval. But that is only if the tribe has a BIA approved, what's called TERRA agreement, so Tribal Energy Resource Agreement, or they're working, or the entity applying for the right-of-way is a Tribal Energy Development Organization, or TEDO. And TEDOs were authorized under the 2017 amendments to this statute. Under this statute, the tribe can grant a right-of-way on tribal lands only, not on allotted lands, but on tribal lands to an entity for energy development purposes, but the right-of-way term cannot exceed 30 years. This also allows tribes to do it without having to go and obtain BIA approval. So without having to obtain BIA approval, you, for example, don't trigger NEPA, and you're not going to have to do a full NEPA review if you aren't going through and having to obtain BIA approval. The line has to go to a generation, transmission, or distribution facility on tribal land. So there are some, restrictions, but it is supposed to open the door to more energy development in Indian country, which is important now because we're looking at doing wind, we're looking at doing solar, we're trying to do all of these renewable energy projects on Indian land. So with that, we'll do an overview of the regulations in Part 169. As I mentioned earlier, I keep talking about them as being the new regs, but they're almost 10 years old now. The regulations in Part 169, when they were updated in 2015, they rely mostly on the statutory authority of the General Rights-of-Way Act. The previous regulations for rights-of-way on Indian land had actual specific sections or specific regulations covering power lines or covering gas lines and things like that. And it made it difficult to work with those regulations because you weren't sure exactly what regulations were supposed to apply. Maybe your right-of-way document didn't expressly give a statutory authority in the four corners of the document. And so then you look back at the regs and you're sort of like, well, I don't know if this one specific statute for power lines, for example, one specific regulation for power lines is supposed to apply to this right-of-way or if it's just a more general one. So when they updated the regulations in 2015, they basically said, okay, we're taking out all the specific regulations for power lines and oil and gas lines and things like that, and we're saying it's just all subject to the General Rights-of-Way Act. It clarified the processes for right-of-way documents, allowed for BIA to disapprove for rights-of-way if there's compelling reasons, and the Bureau of Indian Affairs is supposed to defer to tribes for the amount of compensation that is received. So it's not, the regulations, when you read through them, it very clearly states, for tribal land, we'll defer to whatever the tribe wants to do. But for individual land, the BIA has some very specific processes and requirements. Yeah, so I should have made an announcement. Okay, if you have a question, please go to the microphone so we can catch all of these on camera.
So the new regulations then are regulations. Does that mean that the condemnation actions for, like telephone lines and things like that are no longer authorized under those old regulations?
So they're still authorized because there's statutory authorization for them. Mm-hmm. It's just that the regulations, it's a good question. I don't know how the regulations tie in off the top of my head without going back and doing a deep dive into the regs. But the General Rights-of-Way Act did not supersede any prior laws. So if there's condemnation that's authorized under any prior statute, it's still authorized today.
And is it just like a typical condemnation action like you would see on any other land for rights-of-way, like, public highways, things like that?
So condemnations on Indian land are a little bit different in that the United States has to be joined as a party, and failure to join the United States as a party will actually lead to sort of failure of the condemnation action.
Okay.
There was a really interesting case involving the city of Tacoma, where the city of Tacoma had condemned several allotments back in the, I think, 1930s for power projects. and failed to join the United States as a party. And so the United States actually filed suit against the city of Tacoma like in 2000 for failure to join the United States in those condemnation actions, and won. So,
Okay,
yeah.
that's helpful. Thank you.
Yep. All right, so I mentioned that the quote-unquote new regulations are supposed to be streamlined. And why? Well, because we had all these different regulations that were specific to certain statutory authorities. So it just made things rather confusing. And it brought all the regulations under the 1948 Act. Excuse me. So there's 6 parts. We are not going to go through all of them in depth because I don't want to put you guys all back to sleep at 9 o'clock in the morning. But we're going to do some of the highlights. So, 169.3 says that, this applies to all Indian land, and it makes clear that BIA won't collect compensation due to fee owners. So if there's any fee owners that are on perhaps an individual allotment, like they inherited in fee, BIA will not collect any compensation that's due for the right-of-way. And they also don't count those interests when they determine the amount of consent required for the right-of-way. So rights-of-way require only 51% consent, but that's of the trust interests. Fee interests aren't counted. 169.9, what laws apply? So all federal laws apply to rights-of-way. And then tribal laws apply to the extent that they're not inconsistent with federal law. But it also says that state law doesn't generally apply. And for those of you that are lawyers in the room who are familiar with the case Straight v. A1 Contractors, that actually said that, tribal law doesn't apply, state law applies. Well, the regs took a shot at that, essentially. Again, 169.10, jurisdiction. So tribal jurisdiction is not diminished. The land under the right-of-way is still Indian country. Thank you. And again, that regulation is an attempt to get at the holding in Straight v. A1 Contractors. It contains a taxation provision, so permanent improvements, activities, and the right-of-way interest itself are not subject to state taxation, but they may be subject to tribal taxation, which is an opportunity for tribes. You can pass a tax code that could tax, fiber optic lines that are running through rights-of-way within the boundaries of the reservation. And because those because those lines are generally not owned by the tribe or tribal members, it would give the tribe an opportunity to actually collect property tax revenue. 169.007 is an important regulation to know about, know that it's there, because it provides for retroactive application of these regulations to any right-of-way that was authorized prior. So it provides for retroactive application, but it says if there's a conflict between these regulations and the language of the authorizing statute for the right-of-way, or the language in the actual 4 corners of the document, then the language of the statute or the document controls. So you end up having to do this sort of hokey pokey, right? You look at the regulations on mortgages, for example, and you say, okay, mortgages have to be approved by the landowner and by the Bureau of Indian Affairs. But you got to go back and check the 4 corners of the document. Okay, well, go back and look at what the document says just in case, because the document was perhaps approved in 1970. And you look at the document, and in my experience, 9 times out of 10, the document doesn't say anything about mortgages. So let's say the document's silent. Okay, well, then you go back to the regulations and say, okay, well, the 4 corners of the document don't say anything. So then you go back to the regs and say that the regs apply. Sometimes there is something in the document that says, mortgages are expressly authorized, or assignments to entities that are a subsidiary of the original grantee are expressly authorized. Sometimes you do find language, but most of the time you don't find language on that. And where I think it's really going to come up, or where I've seen it come up, is in, like I said, assignments of rights-of-ways, mortgages, and piggybacking. Again, these regulations affirm that rights-of-way on Indian land are not subject to state law. The mere grant of the right-of-way in no way diminishes the jurisdiction of the tribe over Indian land, regardless of whether the land is tribally or individually owned. Sort of clarifies this idea that came out of Strait that rights-of-ways create, I want to say, like these canyons of state jurisdiction that run through Indian land. And the regulations are saying, no, that's not actually how this works. The land underneath the right-of-way is still in trust. It's still part of the allotment, and it's still subject to tribal jurisdiction. Rights-of-way are not subject to any state taxation, including any tax on permanent improvements. They affirm the right of tribes to tax those improvements, activities, and the right-of-way interest itself. So again, it's an opportunity for tribes to generate revenue. With these regulations, the BIA added an entire subpart on service line agreements. Previously, there was just one regulation that discussed service line agreements. And again, service line agreements, even under the previous regulations, did not require BIA approval. So what I saw quite frequently was utility companies who wanted to come in and run an entire transmission line on a service line agreement. When the regulations were updated in 2015, they added subpart B, which is an entire subpart on service line agreements, and it gives you much more information on when they should be used and how they should be used. So the service line agreements regs are they're limited access to supply one tract of land with utilities. And if the line crosses many parcels, it's supposed to be a right-of-way, not just a service line agreement. Service line agreements can go a little bit faster than a right-of-way, so an appraisal is not required, a survey is not required, BIA approval is not required, but a copy of the service line agreement along with a map or diagram of where the utility line is located has to be recorded with LTRO, because we want to have a record of where these things are, right? And there are sort of less stringent requirements for a right-of-way, which is why I've seen utility companies want to come in and do a line that crosses multiple parcels and call it a service line agreement. Or in their terminology, in how they normally run their business, they would call that a service line agreement. And we say, no, in Indian trust land lingo, that's not a service line agreement, that's a right-of-way, and we need to actually change the terminology of the document. So yeah, right-of-way versus service line agreement. Service line agreement do not require BIA approval, only the approval of the legal authorized user of the property, so that would be the owner, or that could be the lessee. If there's a valid lease on the property, they are the legal authorized user. They do not require a formal survey or legal description, do not require an appraisal, but they can only be used to serve one parcel or leasehold. If it extends across many parcels, or if it extends to several leaseholds on an allotment, it really should be a right-of-way. Subpart C just has the sort of nuts and bolts of what's required for a right-of-way. Written request, survey, bond, notice to landowners, landowner consent, an environmental assessment, because BIA approval is going to be required, so you're going to have to do some sort of NEPA analysis, and then evidence of compliance with tribal law. Again, because these regulations were drafted to be deferential to tribes. The appraisal has to be no less than fair market value. It has to be approved by the Appraisal Valuation and Services Office, which used to be known as OST. Consent requires the majority of interests in an allotment. So if it's a tribal trust parcel, you need tribal consent. If it's an individual parcel, you just need the majority of the landowners to agree. That's actually based on the interests in the parcel, not the number of landowners. So if you have 100 landowners, you don't need 51 of the landowners to consent. You need the landowners based on their percentage. You need 51%. So, if you have landowners who own a 10% interest, you will get to 51% faster if those 5 or 6 landowners have consented, because then you have 50 or 60% consent. Tribal consent for a right-of-way on individual trust land is not required. landowners, of course, are not going to agree to a right-of-way without a survey and appraisal, right? I've seen utilities say, okay, well, we just need to get an easement from these landowners. And I'm like, okay, well, where's your survey? Well, we'll just figure it out. I'm like, they're not going to give you any consent if you're just like, yeah, we want to run this line through their land, and we'll just figure it out when we get there. And then they're also not going to consent without, an idea of the money damages that are due. And the interesting thing with consent, so if you're used to working with leases, we're used to this sliding scale of consent that's required under the Indian Land Consolidation Act. So under ILCA, you have the sliding scale of if you have this many owners, you need this amount of consent. That doesn't apply to rights-of-way. It's only 51% consent. The majority, that's it. The final rule actually says that the ILCA requirements were considered but rejected because of the statutory scheme that's already been established. Compensation, so again, we've talked about this. Fair market value appraisal is required. The tribe can waive an appraisal for tribal land, and individual landowners can waive an appraisal if there is 100% consent of those landowners. So one of the projects that I did frequently at Muckleshoot was where we had vacant allotted land owned by a number of fractionated owners, and the tribe was willing to go in and put in the roads and the infrastructure for those landowners to be able to have homes built or to be able to purchase a manufactured home and put it on the property. But that would require the allottees to grant the right-of-way to the tribe. And in that situation, the allottees were willing to waive the appraisal that normally would be due because they are, in exchange, receiving roads, water, power, sewer, gas, electric. The tribe is spending literally millions putting all of that in. Piggybacking. So we mentioned this earlier. 169.127 is a regulation that's specifically intended to get at piggybacking. So under the statute, it says that public highways can be opened, quote, in accordance of the laws with the state, or with the laws of the state. And that allowed to multiple uses being made of highway rights-of-way, so that you would see, like I said, power lines or fiber optic lines or what have you. 169.127 says that you can only use the right-of-way for whatever purpose it was originally granted. So if it's granted as a road and it doesn't provide for any other purposes, that's it, you're stuck. If it says ingress, egress, and utilities, then sure, it would reasonably allow for water and sewer, for example, to come down that same right-of-way. The previous regulations were silent on the issue, and so you ended up with, like I said, all of these multiple uses within highway rights-of-way. Prior case law had said it's allowed as long as it's allowed under applicable state law. But they specifically prohibit it if the state, for example, wants to allow fiber optic lines to be put in a state highway or power lines within a state highway, and their original four corners of the document doesn't specifically allow for that use, then they have to go back to the Indian landowner to obtain their consent. So subpart D of the regulations talks about term, assignments, and mortgages. It's important to kind of highlight there are different terms. Remember, all those statutes that we went through do have certain term limitations on the term of a right-of-way. So for oil and gas, you can only do a 20 plus 20. Everything else is 50 years, including renewals. And that's for individual land. For tribal trust land, BIA, it's in the regulations, BIA will defer to whatever the tribe wants. Assignments, so prior to the rewrite in 2015, the regulations were silent on the issue of assignments. And what was really interesting is that it turns out that these rights-of-way, I had never thought of a right-of-way as being susceptible to assignment or even mortgage, but they were getting assigned and mortgaged, and we found that there were all these electrical line rights-of-ways on our reservation that were owned by Puget Sound Energy, and Puget Sound Energy was owned by a company in Australia. And they had been assigned so many times over that we actually didn't even know who the actual owner of the electrical lines were or who the actual owner of these fiber optic lines were. So because the old regulations were silent, it kind of resulted in this split between grantees. Grantees said, well, the regulations don't say we can't do it, and our document doesn't say we can't do it, so we're going to do it. Whereas with everything else in Indian country, it's like, well, no, you can't do it unless we say you can do it. Grantees, and then these regulations, when they were updated in 2015, actually required a grantee who received a right-of-way via an assignment must report the assignment to BIA within 120 days. That was of the final rule, obviously, when the final rule was passed in 2015. So that 120-day requirement is long gone. But it was important for our record keeping to know who actually is supposed to be in charge of these lines. You know, I think there was discussion yesterday in one of the sessions I was in of old electric power lines that were owned by PG&E, and PG&E went into bankruptcy. And well, when those lines catch fire, for example, who do we, if we have bad records, we don't know who to go after when something like that happens. Assignments must also have majority consent of the landowner. They must be approved by the BIA unless the original right-of-way grant expressly allows for assignment without approval. Again, that sort of, you get into that retroactivity hokey pokey. The reg says this, the document, you go check the document. Okay, the document does or does not say something on it. Okay, then you go back to the regs. Mortgages, so there was a new section that was included about mortgages. Again, this was one of those situations where apparently these rights-of-way had been mortgaged several times over. And this was sort of crazy to me because everything in Indian country, as I mentioned earlier, has to be approved, usually by BIA. And especially when it comes to mortgages. So for, mortgages of allotments have to be approved by BIA. Mortgages of leases have to be approved by BIA. So why wouldn't mortgages of rights-of-way also have to be approved? But these rights-of-way had been mortgaged out all over as well. And so with the new regulations, or when the regulations were updated in 2015, there was a specific regulation that addressed mortgages of rights-of-way that says you have to have majority consent, has to be approved by BIA unless the original grant allowed for assignment without approval, again, the hokey pokey, and then BIA would have 30 days to approve the mortgage. And again, as I mentioned earlier, there was this sort of disconnect where everything else, every other mortgage has to be approved by BIA. So the mortgages of rights-of-way theoretically should have been approved as well. The right-of-way can only be mortgaged if the original grant allows for mortgaging, otherwise can't. And the grantee must obtain consent for the mortgage from the landowners. So again, there's this whole there's these interests in Indian trust property that have been granted that have sort of gone out to the winds, and we need to keep track of those at least for our own records, so that we know who to go to when something goes wrong, or who to go to if we see a right-of-way being used for multiple purposes that's outside of the original grant. Subpart E was added. The highlight of Subpart E was that it provided for deadlines. Previously, there were no deadlines for BIA to take action on an approval, but Subpart E allowed for that. So failure to meet a deadline for a grant, renewal, amendment, assignment, or mortgages meant that you could go through this process that involved sending a notice to compel action. The regional director has 15 days to act. If the regional director doesn't act, you then follow the process and appeal to the BIA director. Subpart F is compliance and enforcement. So these are all your regulations on investigations, violations, remedies, trespass, late payments, and holdover. Oh, looks like I have a slide out of order. Okay, so we talked about deadlines, deadlines for BIA action. Trespass can be investigated by either the tribe or the Bureau of Indian Affairs. A negotiated remedy can be settled by the tribe on its own, or BIA can do it on behalf of the landowners. There has to be a notice a violation that's written, so written notice to the violator. And it's a violation of federal law, tribal law, or can be a violation of, the terms of the right-of-way document itself. So an example on that would be, there's a railroad right-of-way through the Swinomish Indian Reservation in Washington State. And the four corners of the right-of-way document said that that BNSF, owner of the right-of-way, BNSF wouldn't run more than, I believe, 4 trains a day, and they were limited on the length of the train. And about 10 years ago, the tribe discovered, or filed suit, really. I'm sure they knew this was going on the whole time. But they found that BNSF was running like 10 trains, and they were these huge, long lengths that had not been agreed to in the four corners of the right-of-way document. Well, that would be a violation of the right-of-way. And so the tribe in that situation took BNSF to court. One, BNSF had to reduce the number of trains and had to provide, I think, additional compensation to the tribe. And then actually, sadly, just a couple days ago, I think last week, one of the trains derailed and spilled a bunch of diesel. So can't wait to see that lawsuit. But so trespass can occur as a violation of federal law, as a violation of tribal law, or as a violation of the four corners of the right-of-way grant. I also talked about the case in Wisconsin that has tribal parcels that are perpetual, but then individual parcels that were limited to a 20 plus 20, so a total 40-year term. That term is expired, so they are in, that oil company is in trespass just because of the terms, the four corners of the document. The grantee normally has 10 business days to cure, dispute, or request additional time to cure. Failure to cure can mean cancellation, remedies if there's negotiated remedies available under the right-of-way grant, any common law remedies, and then, of course, additional time to cure. As a general matter, failure to comply with federal statutes and regulations regarding creation of rights-of-way across Indian lands result in no right-of-way being created and the purported holder being treated as a trespasser. So if, for example, a right-of-way is required and they failed to get BIA approval of the right-of-way, then there was no right-of-way. And we all know that there's no adverse possession on Indian trust land. There's no prescriptive easements on Indian trust land. So whoever is the right-of-way holder, if they failed the process in some way, the right-of-way fails and it's void. Void ab initio. Holdover after expiration or cancellation of a right-of-way is a trespass. There's common law remedies, and I know that this was discussed a little bit earlier. Tribes, allottees, and the Secretary of the Interior can pursue suits for damages, suits for ejectment, or suits for injunctive relief against future trespass. Tribes could also possibly pursue ejectment or banishment from the reservation under tribal law, or perhaps under some treaty right. One thing that's interesting, when they rewrote, or when they updated the leasing regulations and the rights-of-way regulations back, 10 years ago, what wasn't in the regulations before was the sort of landowner rights to self-help. So landowners frequently were like, well, we've been calling BIA, we want BIA to take action, our calls aren't going anywhere. And the landowner right to self-help was not expressed in the regulation. It was always there, like as a legal matter, right? It's always there, but because it wasn't actually in writing, people didn't think that they could take those steps. When they updated these regulations, and leasing was done in 2013 and rights of way in 2015, they actually included express language that said that BIA can take action, but also nothing prevents the Indian landowner from availing themselves of self-help. So, for example, if they had a expired right-of-way document, an Indian landowner could take the grantee to tribal court and say, hey, under common law, they're trespassing because their right to use my property has now expired and they won't leave. So that right has always been there. It's just now down on paper in black and white, sort of as notice, like, yes, and you, of course, have the right to self-help. Burden of proof for common law remedies. In all trials about the right of property in which an Indian may be a party on one side and a white person on the other, the burden of proof shall rest upon the white person whenever the Indian shall make out a presumption of title in himself from the fact of previous possession or ownership. And that's actually a statutory provision. So the burden of proof is on the grantee. If they have an expired right-of-way, they have to show why it's not expired. Or if they're in trespass in some way, they have to show why they're not in trespass. The Indian landowner is not required to show anything more than, hey, I want this person off my land. So we'll go over some somewhat recent cases. Seminole versus Strandberg is actually a case on the leasing regulations, but the tax provisions of the rights-of-way regulations are identical to the tax provisions that are in the leasing regulations. So I talk about this case when I talk about rights-of-way because it's got some precedential value. But this was a test of the 2013 tax provisions in the leasing regulations. Those regulations, of course, say that permanent improvements are not taxable by the state, activities under a lease aren't taxable by the state, and the possessory interest is not taxable by the state. Of course, the state wanted to tax. So the state was imposing a rental tax on all rents and leases in Florida, including those on Indian trust land, and a utility tax, so a tax on the gross receipts of utility services sold at retail. A lower court found that Florida could not impose the rental tax on those leases because that was Indian trust land. But when it got up to the Court of Appeals said, yes, rental tax is bunk, it can't be imposed, but the utility tax is upheld. And they upheld the utility tax on this incidence of the tax test, which is a test that's used in taxation, but it basically says that, a tax is valid if it, especially in Indian country, a tax is valid if the incidence of the tax does not fall on the Indian landowner. And it's sort of this, in my mind, this sort of legal fiction, because in a utility tax, so the way Florida statute was written, the tax is paid by the utility company. Does the utility company actually pay the tax? No. They, again, poop rolls downhill. So they eventually, assess that tax on the ultimate user of that utility service, which, as we know, is the Indian landowner. So at the end of the day, the Indian landowner is paying the tax. But because the way the statute is written, and the statute is written so that the utility is supposed to pay the tax, the court upheld the rental tax or the utility tax provision. And the Supreme Court denied review of that case in 2016. A case on expired rights-of-way, so U.S. versus City of Espanola, about water and sewer. So these are rights-of-ways that expired in 94 and 2002. Renewal negotiation failed. The city lines were in an ongoing trespass. And so the U.S. filed suit to recover on behalf of the Pueblo. Because, as we said before, there's no adverse possession on Indian trust land. There's no prescriptive easements on trust land. There's either you have the right to be there or you don't have the right to be there and you have to go. Enable LLC, which was a natural gas case. So again, the right-of-way expired. Enable did not reach a new agreement with the landowners. There was an ongoing trespass. Enable tried to condemn these allotments under state law. Condemnation of individual allotments is allowed. There is statutory authorization for condemnation of individual allotments, but there's no statutory authorization for condemnation of tribal allotments. And in this particular case, the tribe was a small percentage landowner in these allotments that Enable was trying to condemn. So I think the tribe had like a 2% interest in some of these allotments. Once the tribe owns an interest, it's tribal land and it's not subject to condemnation. So yeah, 1% of the interest was owned by the tribe. The tribe couldn't be joined in the case because tribes have sovereign immunity, so they're a necessary and indispensable party. Can't be joined, so the case has to be dismissed. Oh, I thought there was a sister case to this where it was the landowners actually suing Enable for trespass. And the landowners wanted Enable to get their lines off of their land. This was an oil and gas line right-of-way that it was a 20 plus 20, so total 40-year term, and it had expired. And the landowners actually won on that case. The court sided with the landowners, rightfully, and said, yes, the pipeline is in trespass. It has to be removed. And I don't think that I have seen an update as to whether or not that pipeline was actually removed. And with that, we are to the end of my PowerPoint presentation. I think we have 30 minutes for questions. Oh, and there's going to be little blue, oh, are they? Yes, evaluation forms. So Brenda, my lovely assistant, will be handing out evaluation forms. And if you have any questions, please use the microphone in the center of the room so that we can get the question recorded.
Good morning. My name is Justin. I'm interested in asking a question on some, I guess, how the regulations are impacted on trespassing cases where it involves another federal, I guess, department. So you have a trespass case where it involves, I guess, a Department of Energy corporation or entity on a, I guess, federal trust land. Is there any case law that, I guess, is comparable to those cases?
I don't know of any off the top of my head, but I know that there are probably millions of little trespasses like that, whether it's a utility line that is owned by, a separate entity within the Department of Energy. So, like in the Northwest, we have Bonneville Power Association, or with water and sewer lines that have been extended by Indian Health Service. I know when I worked at Muckleshoot, there were several IHS water lines that were extended to allotments that there was absolutely no paperwork for. So, and not that we want to trespass a water line so that it has to be removed, but we should get it documented in some way. We like to have good land records. But no, I haven't seen anywhere it's the federal government taking up an action against another federal entity or federal agency.
I'm from the Fort Hall Reservation in southeastern Idaho. Mm-hmm. And we have several different kinds of right-of-ways, just like probably a lot of other tribes with a large land base. A lot of the power lines that came through in the past were all negotiated by the BIA, and of course they really fell short of what the real value of that was. The tribes have taken over that, and instead of looking at what the BIA did in their methodology, the tribes came up with a figure of, here's our reservation. You got a line that comes through the reservation. Mm-hmm. And if you want to continue with your right-of-way through the reservation, you're going to have to pay us the amount of what it would take for you to go from here around the reservation. And of course that adds up quite a bit. So in order, I guess it's opportunity cost or whatever they call it.
Yeah.
So we've been doing that, and the BIA kind of stood back and watched that happen and didn't object to it. The other kind of right-of-way we had was allowed back in the late 1800s when the railroad started coming through the reservation. Okay, there was a north and south line that went through the reservation. It was kind of put on hold and told them that they had to get a right-of-way through the reservation. And instead of coming through the tribes or coming through the Bureau of Indian Affairs, they went straight to Congress. And Congress granted them a right-of-way through the reservation. But in that right, they said, you can use it as long as you use it for railroad purposes. And then an east and west line came through. Basically same language. Once, it's a reversionary rule. So once the railroad quit using it for railroad purposes, they were supposed to revert back to the tribes. Well, we've been battling for the last 20, 25 years. And I asked, how could such a simple language be muddled up? And you don't have the government backing you up. You don't have the BIA kind of not backing you up. the tribes seem to be standing alone in trying to get this land back to the tribes. Well, since those things happened back in the late 1800s, then the Dawes Act came and took all that land. But it did not. But we're saying it did not take that right away. That right away is still intact. And so we've been battling with them, and it come right through the city, right through one of the cities. It's called Pocatello, and it cut right through the middle of the city. The city built on both sides of the railroad right away. Now they're crying around, oh, the Indians are going to come over and they're going to split our city up. We don't get along with them. They're always suing people. They're always doing this stuff. I mean, you know,
Yeah.
a city with one of our chiefs' names is acting this way. It's kind of odd. But when I hear a lot of these things, and it sounds so simple in remedy, it sounds so simple that way, and the realities of things, it's not. And you have to go to court for somebody's lifetime before somebody makes a ruling on it. So, you know, I just kind of want to, I'm not asking you to give us an answer because your answer might be the same as ours and it's no good. So I'm just want to come up here and say that a lot of these right-of-ways, you know, they can be an advantage for a tribe and they can also be a detriment depending on what's coming through. Now the railroad, we used to put a pit tax on the rail line that was coming through the reservation on the north and south.
Sure.
But once they started hearing that the tribes don't own that land anymore, they quit paying the pit tax. And so I imagine their tax is going to build up until whenever a decision is made. My question is, rather than going to court, rather than talking with all of these cities and counties and the railroad itself and all of that stuff, I said, why don't we go back to Congress? That was their intent to allow that. Why are we in court? Because the court right now isn't on the tribe's side. They're looking for ways to take that land away from us. So I think, you know, depending on how your right-of-way was granted, I think you really need to look at that to make a better avenue of getting that land back. And I think our tribe is probably going to eventually go back to Congress. But sometimes Congress, and especially this one, may be a little iffy. During the Trump administration, we didn't want to go to Congress. There was a lot, I mean, it just depends on the powers to be in Congress. And a lot of times, they may give you a good warm feeling about things, but the realities of things, they're going to be looking out for the state's best interest, the citizens of the United States' best interest over the tribe's rights. So I think, you know, a lot of this needs to be timed, and I don't know if other tribes are going through this type of thing, but you know, we've been asking for support, we've been going here and there. I found out that NCAI support didn't mean a dang thing. You get a piece of paper and you shove it in their face, oh yeah, well, okay, and that one is done that way to that. So any large organization that may support a tribe, a lot of times that's not really looked at or given any credence to it. So a lot of times the tribes have to fight on their own. And I think, you know, I get so frustrated because, you know, I've been involved in our tribal politics for over 50 years now. And a lot of the stuff that we brought up way back then is still being discussed, still being decided.
Yeah.
So I think BIA a lot of time is no help. In fact, if anything, when it comes to right-of-ways, they are a detriment because of their methodology. So I think tribes need to get your own stuff together
Yeah.
and look out for yourselves, because I don't believe anybody else is going to be looking out for you. And I just wanted to express that today when I seen what this was all about, and I thought that you make it sound so simple, and the realities of things is not. Thank you.
It is not. Thank you. And you brought up a good point that I kind of glossed over in the discussion, but fair market value. So normally fair market value is determined by just appraising the land itself. Well, when you're just appraising a strip of land that goes through perhaps several parcels, it may not be worth that much. Like the actual land value may not be worth that much. And so you do want to take a look at other methods of valuation. So the gentleman from Fort Hall brought up the build-around cost. So if you have an existing use that is on perhaps an expired right-of-way, like I talked about, the oil pipeline in Wisconsin, what would the build-around cost be for that company to dig up their line and have to secure new rights-of-way that skirt around the reservation and then link back up? That can be in the tens of millions, especially depending on where you are. Like I saw, an expired right-of-way in Washington where it was, at the time the right-of-way was granted, all the land in the area was rural, but 50 years later, when you're talking about an expired right-of-way, all of the land was urban. And what is the build-around cost? What's the cost of acquiring a right-of-way or condemning all those other properties in order to build around the reservation? Another method of valuation is valuing the goods that are being transported through the right-of-way. So for example, in an oil pipeline right-of-way, how much oil is being pumped and what's the sale price? And we can put a dollar amount on that, and the tribe can ask for, or the landowners can ask for that value to be the purchase value for the right-of-way and not just the straight land value. So there's lots of different ways of valuing these rights-of-ways that are not just the land value, because the land value will probably be minimal. The other thing that you made me think of is that, and I frequently say this, that rights-of-ways are like the great Pandora's box of Indian country. Once you start looking, you will find more and more trespasses, especially with little electric lines and things like that. But if you go and you do like an actual boots on the ground, take a look at a parcel, look at what's there, look at the things that you have on paper, so the encumbrances that are listed on your title status report versus what the actual factual is, what you're seeing there. There can be, and there has been, discrepancies. Sometimes it's the width of a road. It's been widened over time, and originally they were only given a 30-foot wide road right-of-way. Or they have a road right-of-way, and they've packed on additional uses so that there's water and sewer and electric all going along that right-of-way corridor as well. But once you start looking, I think you'll start to find these things. And once you start finding them, then you perhaps have an opportunity to renegotiate some of these rights-of-ways. So if you have a right-of-way that was granted as a perpetual right-of-way, and you feel like you're stuck, start digging into it a little bit more, because you might not be stuck. There might be, violation and piggybacking of the piggybacking in violation of the regulations, or some other violation of the four corners of the document, like in the Swinomish trains, right? The document said 4 trains a day, and they were running 10. It's an opportunity to get that grantee back to the table to renegotiate the right-of-way. And you could even talk about a build-around cost at that point. So,
Morning, everybody. My name is Linnea Jackson. I'm with the Hoopa Valley Tribe. So I kind of wanted to echo what the gentleman said about the right-of-ways that were negotiated at the time when the Bureau was supposed to be upholding their trust responsibility. For one, they were not negotiated in favor of the tribes. There wasn't proper compensation. There wasn't proper protections or language to help promote their tribal sovereignty at that time. And so now when the next generation is coming in and trying to get projects approved, we're having to operate on a law that was set up for the detriment of tribes. And so that makes it hard to deal with. For one, the trust records might not be there. The BIA, who I work well with, but they've transitioned from software, and sometimes those documents either were kept in a warehouse and they got waterlogged, thrown away, records gone, or the programs had transferred and that data didn't transfer along with that, records gone. And so that trust responsibility was not upheld, so we don't have all the documents at our fingertips to operate with. I don't think those should be perpetual all the time with electricity, telephone, state highways. I think there should have been room there for negotiation. So when we're working on broadband projects, which I'm currently working on, we also do water and energy, the same thing applies. And so we're having to deal with state highways, so that's a different jurisdiction. We might need to be dealing with a county road, different jurisdiction. And then the allottees, and then tribal trust properties, and then the fee owners. And so there's so many different things that we have to negotiate without the resources available. Those BIA compacts, which in the HOOPA's case has been the same since the 90s, have not increased. So the larger projects that we have to deal with, the upgrades to software, everything, but the money stays the same. There's no investment back into that compact, not only for Bureau staff, but for tribal regulations. So it's a detriment on those things because we're trying to maneuver those. We're not giving the proper resources to do that. So I guess my comment is when I'm trying to work with fiber projects, water projects, energy projects, it makes it really hard to adhere to not only the project timelines, because for the infrastructure money that's come out for a lot of tribes, we are having a certain deadline where we have to complete that or we lose the money, right? But then we have to maneuver right-of-way, landowner consents, appraisals, surveys, and so those two don't match. And so I think there needs to be if you're going to invest, if the federal government is going to invest that much money, or states are, the resources have to match that. And so for some of these projects, they're issuing like expedited permitting processes. I'll use the Bureau as an example, but they're not giving them money to ramp up in resources and have additional staff. They're putting that on the existing staff to be able to handle all of the influx from every tribe that wants to improve their reservation. So I just kind of needed to say that, because I could go on and on about some of the right-of-way issues. Back to the service line agreement, we had done a fiber optic project that was aerial attachments to existing poles. We tried to do a service line agreement, record that with LTRO, and they're like, well, in order to have a service line agreement, you need a right-of-way there to attach it to. But those poles, being that electrical or telephone, have been there for decades. And so were they not recorded correctly? Were they never negotiated? And so that puts us in a hard position when we're trying to implement laws that are enacted. How do we maneuver that? So I kind of just wanted to say it's really, really complex for tribes because we have to deal with so many jurisdictions and not given proper resources.
Okay, thank you. And you brought up a good point about missing records, and I've run across that before. The way I approached it, though, was the city had actually contacted me and said, hey, we're going to be doing some improvements to this road, just FYI. And I got the notice and said, okay, and I went and looked at the title status report, and I said, I don't see that you even have an easement or a right-of-way for this road. So I put it back on the grantee, right? I put it back on the city. I appreciate that you're going to do construction. That road definitely needs improvements, but I don't see that you have any rights to do that. So show me your documentation. Show me your papers. Show me your documentation that allows you to go and do this. There's other places you can look to. Obviously, the county records. I know a lot of times, at least in the modern age, things will get recorded twice. So they'll get recorded at LTRO and they'll get recorded at the county. So there's a record at the county as well. You could try county records or try the grantee. If perhaps some right-of-way document's been lost and you see that there's this road that goes through an allotment and it's a state highway, it's on the state, it's got a number, it's got a state highway number, but you don't have a copy of the document, just ask the state for it. Ask the grantee, show me what you got. So, but it's so complex dealing with allottees and tribal parcels and then all the jurisdictions that have to be involved. And everyone has their own different way of doing things. So like one utility company might do something or might want to do something differently than the other utility company, and you felt the way to do it in the past. Maybe I do make it look a little bit too easy, but it is hard. I agree. I think there was another question. Yes.
Yeah, dealing with the Bureau, we'll get your thoughts on some things. Now, appraisal and negotiation are two different things, right? So the Bureau does appraisals, which is usually before and after, like you said, what's the land worth? The Bureau will do comparable transactions, but usually those are non-disclosure. So there's very little the Bureau can do there unless they know what comparable transactions have done. The tribe, negotiations with the tribe are the comparable transactions. So, and those have non-disclosure, like I said. So the Bureau on a lot of land should see what the tribes negotiated and then match that, is the way we look at it. So I think it's, the tribe goes first with all these alternative methods, and appraisal is mostly just what's the land worth or what's comparable. So I just want to be sure all the tribal people understand the role of the Bureau as far as valuation. Now, the old appraisals, they were supposed to be before and after. Whether they were sufficient is another story.
Yeah.
On what the gentleman said about when the U.S. is the grantee or the taker, there's a statute of limitations on possession, getting possession back from the U.S., as I understand it, of 12 years. So in that case, if they've been there 12 years, there's very little anybody can do about it, right? So now on broadband, my thinking is maybe we should set up some sort of a summary procedure. Inverse condemnation is allowed too, right? Not just condemnation of allotted lands. And most broadband is going to be tribal and allotted. So on allotted, to expedite things, my thought is allow inverse condemnation and pay after the fact, not have to get consent, and have some sort of a quasi-judicial to determine how much that's worth after the fact. I want to get your thoughts on that. And so I think those, I think that was all I wanted to get your thoughts on. I think those are some things. I don't mean to be too defensive about what the Bureau does, but there are limitations.
Yeah. Thank you. So inverse condemnation. Okay, we know that the federal government has the authority to condemn, and state and local governments have the authority to condemn. Tribes have an inherent right, just as every other sovereign does, to work a condemnation proceeding. I've actually never seen a tribal condemnation proceeding. I've never seen a tribe go against an allotment, for example, in a condemnation proceeding. That being said, if we are up against all these timelines for the rollout of broadband, it might be worthwhile to work some sort of inverse condemnation, to just go in and put the lines in and then figure it all out at the end. We would also, I mean, tribes are subject to, why am I blanking on the name? The Indian Civil Rights Act. So ICRA, Indian Civil Rights Act, which says that there can be no taking without just compensation. So it would essentially be a taking by the tribal government. You're talking about inverse condemnation. That is basically a taking. And they would still have to pay just compensation and do some sort of due process, I think, through the tribal court. But it could be done. I think that is a reasonable alternative. It may not work with every tribe because I think that there's a lot of resistance in tribal governments to rolling out some sort of condemnation or taking of allotted lands. But I think for this particular situation, where there's so much interest in getting broadband out to people who are living on reservations, I think that is an option. But it's up to all the tribal leaders in the room here to decide if that's an option for them. So, yeah, thank you for bringing that up.
Good morning, everybody. My name's TJ Loretto. I'm the Realty Officer for the Pueblo of Jemez in New Mexico. There's a couple things that I want to bring up to you as well. One is a right-of-way situation that we have with the Jemez Mountain Electric Co-op that we got there in Jemez. So the Pueblo of Jemez has been recognized as a Hearth Act tribe as well. So we're moving forward with a lot of stuff. But back in the early 2000s, the Pueblo of Jemez did 638, a majority of BIA functions. Realty was one of them. And then since then, the Bureau has kind of basically pushed us aside, which is the Southwest Region Office. A lot of stuff isn't going through. Talk about lost records and all that. They told us, we already gave you everything. It's up to you guys. But then again, yet, whether or not now that we're a Hearth Act tribe, right-of-way is not covered in that. Right-of-way is not a part of that. So we're getting this back and forth battle with the Bureau on this. So, the Pueblo of Jemez has decided to go against filing suit against the BIA Southwest Region for a lack of the breach of trust. So now we finally got heads turned from central office and also even the DC area as far as what's going on with the Pueblo there in New Mexico. And I'm pretty sure it's not just there, it's pretty much nationwide that this is going on. A lot of breach going on. So, we have a lot of lands that we're obtaining now by basically purchasing back our own properties that we had. And a lot of these service line agreements run through there. Some of these major power lines run through there. And now we're having trouble getting the BIA to turn heads and help us keep these these service lines in place, intact. So that's one thing that we're fighting now. And then the other thing, you're talking about condemned lands. Back in the 40s, the BIA condemned lands within our reservation there in the Pueblo for a school, for the BIE to put a school there. And now BIE wants to bring, that E-rate broadband stuff to that school. But then again, it's sitting in a place where this line has to come to trust lands first before they can move that. So now we're fighting them again on this case, stating that, turn those condemned lands back to the tribe. There's no reason why there should be a donut in the middle of our reservation. That's what's going on right now.
Yeah.
So through this lawsuit, we have filed through that, and we've got BI finally, it took just a letter and a tribal council resolution stating them that they can return those condemned lands back to the tribe through GSA process. Certain little things like this, they drag their feet on that. It's what we're faced with on a day in, day out basis. But, it's, I'm just trying to put that out there to everybody that, it can be done. We're a small tribe. We only got 3,000 enrolled members. But, we're pushing all this stuff to have that happen. And as far as the realty officer of the tribe, it's like they're just saying, here, you take over. It's all yours. But then when it comes down to trying to get them to help us with certain things that they're in charge of, we're having that trouble right now. So I just wanted to bring that out to everybody. Thank you.
Yeah, and you reminded me of a regulation I actually forgot to talk about in the presentation today. But there's one section in the right-of-way regulations that says that, essentially it says that if a tribe wants to grant a right-of-way to a tribal utility, to a 100% owned tribal utility, they can grant a right-of-way to that tribal utility on tribal lands without having to get permission of the Bureau of Indian Affairs. It doesn't have to go through the full right-of-way process. The tribe can come up with whatever process they want. So it's a little bit like the Hearth Act in that, it allows the tribe to grant rights of ways to a tribal utility without having to seek BIA approval. But that is an option that's out there. And I know at least one tribe, I know Navajo, has developed what they call their own tribal access authorization regulations for their tribal utilities to be able to get rights of way through Navajo land without having to go through the full BIA right-of-way process.
I'm Franklin Martinez from the Pueblo of Acoma, and I work for our realty department and our natural resource department. But some of the issues here are with right-of-ways, but there's also other alternatives as far as leases or license agreements. And that's something that we're using more now because it doesn't hold you to that 20 years lock-in with BIA. With the lease agreement, you can 7 years, 10 years, and get out of that contract with these big utility companies. Because we did it with our co-op in New Mexico. Now we actually run our own electric company there on Acoma. And so, it was a lot of process, but it was easier. And right now we're looking at our gas company, taking over our gas company and all the utilities that come on Acoma. We're trying to self-sustain ourselves, and because we see that these co-ops, they don't assist us tribes. we've never seen our co-op do anything for our tribe. So when we were renewing the right-of-way with them, they wouldn't budge. They didn't take our appraisal, what we offered. And so we took them to court, and they made an agreement or made a deal with Acoma. They told us, if you can do it in 3 years, I'll sell you all the utilities that are on Acoma for $1. Well, guess what? We did it. So now we own our own utility with all their equipment. So that's some of the things that you can look at. A license agreement is just tribal. You don't have to go through the BIA process. And that was easier for us. Now we're looking at broadband, of taking over our own broadband on Acoma. So, there's other loopholes that you can fall into, that look into, that will help your tribes and get out of these big leases and agreements with these companies, because they don't do you no good. Even condemnation with the highways, right now they want it to expand on a intersection on our reservation. So, highways, they don't want to pay, a fee, right-of-way fee. So we told them, well, give us jurisdiction over the highway that runs through Acoma. And they did. So now every time our officers stop somebody, the money goes to Acoma. So that's, there's all kinds of loopholes out there that tribes can fall under, and it'll help your tribes out. Thank you.
Thank you. Yeah, I mean, the great thing about, you mentioned Hearth Act leasing. So Hearth Act leasing and those tribal access authorizations that are in the rights-of-way regulations, those can really speed up the process. The only drawback is that they're only available for use on tribally owned land. So if you do have to cross allotments, then you do have to work through the BIA processes for either leases or rights-of-way, one or the other.
Don't you think that leaves that more for negotiation? The fact that's in the regulation maybe gives the tribes more leverage to negotiate that, which they may be successful or not, but one way or the other address that in negotiation, and the applicant may say no way, but at least then you'll have some certainty on it. So don't you think that's a better way to do it, if it's win or lose and wait 2 years to get it resolved?
Yeah, I mean, if you're in the position, so that case, so the Seminole case, for example, the tribe was suing the state over the assessment of these taxes. But you can put in your right-of-way document an express agreement on the part of the grantee that they will pay any and all tribal taxes. And then, if they kind of want to hem and haw about it, you can just point to the regulation and say, well, look, the regs say you're going to have to do it anyway. So now, when you talk about agreements, though, the one question that I had immediately was, are you talking about doing an agreement with the grantee that they'll agree to pay tribal taxes? Or are you talking about perhaps a tribal state compact dealing with taxes? And so I know, like in Washington state, as a result of some litigation that the Tulalip tribes brought against the state of Washington for the assessment of sales taxes on the reservation, tribes can enter into sales tax compacts with the state so that they can actually pull back some of the sales tax that is generated on the reservation but then is sent off the reservation to the state. So in a case like the Seminole one, there could be the possibility of the tribe working with the state on the utility tax issue and say, okay, well, if you're going to assess this utility tax, it rolls downhill. It's being paid by our lessees or by our tribal members, so we want to cut and enter into a tax compact with the state over that. Thank you all for your time and attention today.